Hello, I'm Nick Hobden, partner in the law firm of Thompson and Passmore based in Kent, and I'm joined today by Sara Ibrahim, barrister from Gatehouse Chambers, and my colleague Jessica Wells of my team. In this second part of the video about the anatomy of a special educational needs tribunal, we're going to focus on some more issues arising from the bits that we covered in the first part. And I just want to start by focusing on the interrelationship between the county court and the Special Educational Needs Tribunal. Now, Jess, if I can ask you, when parents are contemplating bringing proceedings against a school on grounds that a school setting has failed in their responsibilities under the Equality Act in respect of disability discrimination, in respect of which we've talked about in the first part of the video, they're often seeking money compensation. So can they bring a county court claim before they have started or completed the Special Educational Needs Tribunal claim?
So the first thing to mention is you say that most parents or young pupils are potentially looking for compensation. So it's important to note that the Special Educational Needs Tribunal cannot award compensation. So naturally, the county court is the next step to go. But in answer to your question, no. A Special Educational Needs Tribunal, that process needs to be entered into and finalised before a county court process can begin. So the county court doesn't have jurisdiction to award compensation or to make findings before a Special Educational Needs Tribunal process has been finalised. So the county court is the next step after the Special Educational Needs process has been exhausted. And this county court, usually parents go down that route for two different types of claims. So either potentially a breach of contract claim in relation to that discrimination, or in relation to negligence, potentially by the school.
Okay, but that assumes that they are successful in the Special Educational Needs Tribunal. Otherwise, they can't really rely upon any failures on the part of the school setting arising from those proceedings.
Absolutely, there needs to be a finding in their favour in order to progress that further and to make those kind of negligence claims.
So now I want to talk about the powers of the Special Educational Tribunal, what it can do in the event that the child's claim is successful in respect of a disability discrimination claim. Well, it has various powers available to it, with the exception of an award of compensation. It cannot award compensation. What it can do, however, is to make a declaration that there has been discrimination against the child, which is important because in those circumstances the child's parents then or guardians can go on to make a claim in the county court, as Jessica has just outlined. But the Special Educational Needs Tribunal can also compel the school setting to give an apology. It can also make recommendations in relation to training. It can also direct that the school setting rewrites or amends certain policies where it feels that those policies have had a discriminatory effect on the child, which can't be justified, as Sara has covered in our part one of the video. So those are the powers available to the Special Educational Needs Tribunal. So now we want to talk about how these claims begin. So Jessica, tell me how these claims are started. What's involved?
So the first thing that needs to be considered is actually what is the claim about, so usually disability discrimination. And either the parents or the young person or the guardians of the young person will need to think about, well, how are they discriminated against? So how does it relate to their disability? Do they actually have a disability is the first thing to consider and really underpins the whole claim. So if all of that is the case and they've thought of the ways in which a claim can be brought, then the first thing to do is to make an application to submit a form to the first tier tribunal, Special Educational Needs area. So firstly, there are two different forms that need to be completed depending on the circumstances. So you either have the SEND 4A form, which is for the parent or the guardian of the young person to complete if the individual can't do so themselves or they're underage. Or there is the SEND 4B form, which is for the young person to fill out themselves. And of course they can seek legal advice on how to fill that out. So it's not just for them to do on their own, they're not left to do that. So there are supports available to fill that form out. But it's quite self-explanatory. It goes through the names of the individuals, who you're bringing a claim against, exactly what the claim entails. And there is also a section to outline what the claim actually means and why they think that the school has discriminated against that individual. But you can also, and it's recommended if you can, or if you have legal support to assist you in doing so, you fill something out called a particulars of claim. So it's a more in-depth, lengthier document that really highlights exactly what has happened, when it happened, why you think it happened, and it goes into more detail, and also outlines what kind of remedies you want the Special Educational Needs Tribunal to have a look at. So that's the first thing. That then needs to be lodged, and it needs to be lodged within the right time limit. So I know that that's something we'll come on to later as the time limit concerns, but it needs to be lodged within the correct time limits. Once that's done, it will be submitted to the tribunal, and then within 10 days the tribunal will receive it and will lodge the claim formally within their system. From that point on, the tribunal will lodge a final hearing. Potentially there may be preliminary hearings depending on the issues raised, but usually the final hearing is listed within 20 weeks of that being within that form being submitted. Now it can change depending on the complexities and the way the court operates and how busy they are, but typically it's that 20-week period. Now from that point on, really the tribunal will be directing what happens next. So they will produce case management orders, and those case management orders, both parties, both the claimant and the respondent, need to make sure that they're adhering to, but that can include directions to submit certain documents, to put bundles together ready for either preliminary or final hearings, to produce witness statements and to submit those. So really from that point on, it's kind of case specific, but the tribunal will be directing through case management orders what to do. And then the final hearing will come, and then at that point both parties will attend the final hearing either by themselves or with legal representatives if that's what they choose to do, and then the tribunal will produce within 2 weeks usually of that final hearing their thoughts and their comments or any kind of recommendations and the outcome of that final hearing.
Okay, and is there a limit on the number of witnesses that each side can bring to the hearing to give evidence?
Typically it's 5.
Okay.
So within the application form it usually identifies that there are up to 5. However, you can make a change or a request to change something in the case management order. So that's done by something called an SEND 7 form. So that form can be used to make various amendments if needed. So it can extend potential deadlines, it can change the final hearing date if needed. You can request observers to come along, and also you can request an increase in the number of witnesses. Now the tribunal will only really increase the number of witnesses if they feel that it's necessary to do so, and if that it would really have an impact on the potential claim. But typically it's 5, but that's not a set number, but there has to be good reasoning to increase.
So now that we've had an introduction to how to get a Special Educational Needs Tribunal claim off the ground and what's involved, including the hearing and how soon the decision of the tribunal is made after the hearing, let's focus on things that need to happen along the way. So, Sara, can I ask you what happens, what sort of process is involved along the way in terms of the issues that the tribunal will need to deal with, such as time limits, the disability status of the child, and the knowledge of the school involved who is receiving a claim?
Well, Nick, I'm going to address them in the order you've set them out. Time limits is the most important one. If you're acting on behalf of school, the first thing you need to confirm is whether the claim is in time or all of the claim is in time. So what do I mean by in time? A lot of people are surprised that under the Equality Act, you've got 6 months to bring a claim. And that's a lot shorter than in other types of civil claim, where you tend to have a number of years. So people can be caught out by that. But even though 6 months sounds quite clear, there can sometimes be a lack of clarity. Why is that? Well, think about something like reasonable adjustments. And we were discussing in part one what a reasonable adjustment may be. Now, timing for a reasonable adjustment isn't an ongoing state when it comes to a reasonable adjustment. So, for example, if you don't provide a bit of software that was requested as an adjustment, that doesn't continue as an ongoing act because you are not providing it over a course of months. It's when you make the decision not to provide that software that, in fact, that is when the date starts to run. And that's so important to bear in mind, because a lot of people, when they're making claims, are thinking about it's ongoing.
Yes.
And that isn't necessarily how the Equality Act will frame it. So be very careful when you're looking at time limits. The other point you raise, which is very important, is disability. Now, a lot of people, when they make a claim, it can be everything from a relatively straightforward claim in terms of disability, i.e. there's one disability, or you may have a child who suffers from a package or a number of disabilities. So there will need to be careful attention, usually evidenced by a medical report from a specialist in that field who can talk about whether that is in fact a disability and how long the child has been disabled for. Because you will remember in part one, it's not something that happens automatically, it has to be long term. You will also then have a child, when I talk about having a package of disabilities, not all of those conditions may amount to a disability. So there ought to be a quite careful reasoning as to what the disabilities are and when they start from. So you have a real forensic analysis of the claims in front of you and what you want to focus on when you get to the SEND tribunal. So I think that is a very important thing to do as well. And that will also impact things like what adjustments you need to make and what may arise from a disability. Because if something isn't a disability, then you don't need to look at what arises from it.
Yes.
And there may be certain things which arise from certain disabilities, but not from others, which is why medical evidence really is imperative, because it provides a real structure for not just the school, but eventually the tribunal to look at. And then I want to come on to knowledge. This can be an area where there's debate, because a parent may say you ought to have known, because you will remember there are two types of knowledge. There's actual knowledge,
Yes.
which is easy.
Yes.
I told you, I told the specific teacher at this time that was a disability. That is quite straightforward. Unfortunately, that isn't the only type of knowledge you need to look at. So you may need to look at what is called constructive knowledge. And that is when a school can't say, well, you didn't actively tell me. There may be instances such as prolonged periods of absence. Or if somebody mentions a parent or a guardian when they're having a conversation with a teacher, that there is a potential diagnosis or something of that nature. So within a school, you may have discussions about who was told what at certain times, or different teachers may have been told slightly different things.
Yes.
That may be enough to amount to constructive knowledge. So a school may want to think before they get claims how they make sure that information is being funneled into a place where they can actually do something about it, because otherwise they may face a constructive knowledge type claim which will fix them legally with knowledge, even if they may not have started to take those preparatory steps. So I think those are three quite common issues that tend to come up in disability discrimination claims, Nick.
Okay, thank you. Can I just bring you back to the issue of disability and the disability status of the child? Can you give me some examples of a mental disability, a mental impairment that might amount to a disability under the legislation?
I think that's a good question, and the reason I say that is because with physical disabilities, people tend to find them easier to accept and understand the kinds of provisions to be made, like auxiliary aids, for example, with people with sight issues, for braille and things of that nature. With a mental disability, one such example could be depression. So if you have depression that is having a substantial long-term impact, so that's 12 months or likely to last 12 months, that would count as a disability.
Okay.
Certain types of anxiety, again, if they meet those criteria of being substantially long-term, may also amount to a disability in certain circumstances. But it's not about looking at the diagnosis, but looking at those other components as to whether, as a whole, it meets the definition of disability.
And there's a lot of focus on the effect that the impairment has on day-to-day life, on a child's ability to carry out day-to-day activities such as performance in class, whether they are interested in sport or lost interest in sport, having previously been very good at sport, that sort of thing.
Exactly, and I think that also links to knowledge as well. So a lot of these things can overlap. It's not just whether the child has the disability, but those changes in behaviour could well be a signal that, as I say, could fix you with constructive knowledge. And I think it's important that a school stays mindful of what those changes may be.
So that concludes part 2 of this video, where we've taken a bit more of a deep dive into the nature of the claims that can be brought in the Special Educational Needs Tribunal and the law and the legal principles involved. And in the next part, we'll be talking about how a school will defend a claim, on what grounds, and also the process for dealing with the claims.